Welcome back to lecture 1 part C. Part C is about a classic case of Solomon versus Solomon and Company. This case was decided by House of Lords in 1897. Solomon versus Solomon and Company is a classic and an important case because it is the case that clearly established the separate legal personality of a company. The court clearly held that company has a separate legal entity, it has its own rights and duties, and the individuals who form the company, that is in the shape of the shareholders or in the shape of the directors, they have their separate legal entity. So we will start this case here that Mr. Solomon was basically a leather merchant running a leather and boot manufacturing business for about 30 years. On the demand of his family, he formed a company, Solomon and Company Limited. So when he formed a company, he sell out his whole business to the company. And thus his business was run by the company Solomon and Company Limited. The company purchased the business at the price of 38,782 pounds. That was the amount at that time was fixed for the purchasing the company. Out of this, 20,007 pound shares were issued. 1 pound, 1 share, that was the ratio at that time. While 8,775 pounds were given to the Solomon as a cash and debenture of 10,000 rupees as a charge on the company's property. Here you will have to focus on the charge on the company's property. Means that a debenture has been issued by the company by mortgaging or having a charge on the company's assets. So what is a debenture? Yes, that is an important thing. This is a new thing for you. Rather, maybe possibly we have studied it in pre-med. Debenture is basically a receipt issued by a company acknowledging indebtedness to certain person. What is debenture? Debenture is a receipt issued by company to the creditor. On that debenture backside, certain terms and conditions on which that loan has been given, that is also mentioned. So the business, the whole amount was 38,782 pounds, out of which 20,007 pound shares were issued, 1 pound 1 share, and 8,775 cash amount was given, while 10,000 rupees debenture, because the company at that time was not having such an amount, so therefore debenture was issued that when company get profit, then they will pay the amount. He keep 2,000. He here means Mr. Solomon keep 20,001 shares and distribute 6 shares, 1 share each to his 6 family members, including his wife, a daughter, and 4 sons. So basically, this company was a one-man show company because all the major shares were with the Mr. Solomon. And one thing you must know that in company, when there is voting, voting is not by one member, one vote, but voting is according to 1 share, 1 vote. If a person who has 10 shares, he has he has 10 votes. While a person who has 5 votes shares, he has 5 votes. And a person who has 1 share, he has 1 vote. So here the majority of member does not count in voting, but the majority of shares count. One person who have 10 votes, who have 100 shares, he can give all the votes to one person. For example, Mr. A has 100 shares. He can give all, in case of election, he has 100 votes. So he can give 100 votes to a single person, or he may divide it into 30 votes give to Mr. A, 50 to Mr. B, and 20 to Mr. C. So he can also distribute it. So here, Mr. Solomon keep the authority with him by keeping 20,001 share with him. Then there was a strike in a labor market, due to which there was a depression in the leather business. Due to this depression, there was a loss to the company. The business suffered loss. Mr. Solomon and his wife lent money, 5,000 pounds to the company, and also mortgaged the debenture to Mr. Broderick as security for 5,000 pounds. In order to make the company survive, they give the loan, but still the company did not survive and went into liquidation in 1893. The debts of the company, the total debts of the company were 7,773 pounds, while the assets of the company were only 1,055 pounds. There are two types of creditor now here with the company. One was a secured creditor, that is having the debenture, and other were the unsecured creditors. The secured creditor who have the debenture was Mr. Solomon, who was also the director of the company, and unsecured creditors were the other who were dealing with the company at that time. Now, question arises that who have the better title to claim the remaining assets of 1,055 pounds. Mr. Solomon claimed 5,000 pounds, the debenture amount. So he filed an application with liquidator. Liquidator is a person who is appointed either by the court in case of compulsory winding up or by the company itself in case of a voluntary winding up. So liquidator is a person who is responsible for the winding up process of the company. His major duty is to collect all the assets of the company at one place and also make a list of the creditors and other liabilities of the company, and to pay all the debts and liabilities from the assets of the company. And if there is any surplus, that will be divided among the shareholders according to their shares or according to the article of association. The liquidator rejected the application, the claim of Mr. Solomon, on the ground that it is invalidly issued on, and therefore, as you are the owner of the company, so therefore you cannot claim it. Mr. Solomon filed an appeal in High Court. Justice William also rejected Mr. Solomon appeal, but on a different ground. In his judgment, Justice Williams says Solomon is liable to indemnify the company because it is just like his agent. So what does indemnify means? Yes, you know, we have already studied the contract of indemnity. That is, Mr. Solomon is responsible to save the company from loss. So Solomon cannot claim, rather he is liable to pay all the debts of the company to the creditors. Mr. Solomon filed an appeal to Court of Appeal. The Court of Appeal also rejected the application of Mr. Solomon on the ground that Companies Act 1862. At that time, the Companies Act 1862, under which Mr. Solomon has registered his company, it states that there must be at least 7 independent members who had a mind and will of their own. This is the statement given by the Court of Appeal, in which say that is there must be at least 7 members. At that time, for the registration of a company, the minimum number of members required were the 7. So as the company is dominated by Mr. Solomon by having 20,001 shares, while the other member have just 1 share. So this is one main company and is also a misuse or abuse of the Companies Act. Secondly, the arguments, second argument that the court has given is that the relation in between the Mr. Solomon and the company was there, just like of the trust and the trustee. So therefore, Mr. Solomon cannot demand the debenture, number one, and the amount should be given to the other creditors rather than to the Mr. Solomon. Finally, Mr. Solomon filed an appeal to the House of Lords. House of Lords at that time was in England the highest court, the Supreme Court. Now in 1998, and the Supreme Court has been established in England, but before 1998, the House of Lords acted as a Supreme Court of England. There were 9 law lords who sit as a court. On appeal, the House of Lords gave unanimous decision in favor of Mr. Solomon on the ground of the separate legal entity of the company. The court held that as the company is legally registered under Companies Act 1862, so therefore, after the registration, it is become a separate legal entity. It has its own separate personality from that of Mr. Solomon. And Mr. Solomon is not responsible for the debts of the company and is thus entitled to the debenture amount. So although Mr. Solomon did not get all the 5,000 pounds, but still he get the 1,000 and something that amount, 1,055 pounds. He get it from the company. So this was a classic case in which one principle was clearly established. That company is a separate legal entity. So who enter into contract with a company, it is the company that is responsible, and Mr. Solomon legally entered into contract with the company and give loan to the company. Here Mr. Solomon is entitled because company has issued a debenture which is validly issued, and the amount will be paid to Mr. Solomon. So that is the end of today's lecture, first lecture. This lecture consists of 3 main parts we have already discussed. So what we learned from today's lecture? First, I will say what are the learning objectives of today's lecture. Today's lecture, you came to know that what are the different contents of your syllabus, that how many parts your syllabus is divided. That is the Companies Act 2017, Partnership Act 1932, Law of Torts, and the Moral Code approved by the Pakistan Engineering Council. So one thing you have learned about your course contents. Second thing that you learned, that what is a company. Before this lecture, most of the students, I think they will have no idea that what is a company. Now, any association registered under the Companies Act 2017 is technically called as a company, a simple definition. And the third thing that you have learned here is that company is a separate legal entity. This is a new thing for most of you people, that if you deal with a company and anything you suffer any loss or injury, you cannot file a suit against the directors, you cannot file suit against the shareholders, you will file a suit against the company. So that is the end of today's lecture. Thank you very much. This is a new experience for me also. Inshallah, slowly and gradually, We will try to make it more interesting and more easy for you. You will have to learn all these slides properly. And if you feel any difficulty, you can contact me on my WhatsApp number 0300 and also on the email Safarat Ahmed 87 @ gmail.com. Thank you very much and Assalamu alaikum to all of you. Allah Hafiz.